normally do our Zoom housekeeping tips. This is something we do every week, so feel free to ignore. If you want to be on camera, please feel free. You can find your mute and unmute and your camera buttons at the bottom of your screen, depending on the device that you're using. We ask that everyone stay muted during the presentation so that everyone can hear without background noise. If you want to unmute to ask a question or ask for clarification, please feel free to do so. Um, so these Wednesday Q&As, any of our blogs, any of the information that we give out, unless it is specifically tailored to your association and you have an attorney-client relationship with us, it is not legal advice. This is meant for general information that may be applicable to your association. So if you have a specific question regarding your association or regarding any documents that you've received from our office, if you're one of our clients, please ask the attorney or ask for the our office or your association attorney to answer those questions because things may be different for your association and answers can change depending on specifics in your governing documents or your specific statute. So this presentation, anything in the chat is not legal advice. If you want legal advice, that can only come from your association attorney who has your documents, who knows your statutes, and can give you proper legal advice. We probably will have time for some extra questions today that weren't prepared ahead of time, so please feel free to put them in the chat. If we don't get to your question, please feel free to email it to info@condolaw.net and we will add it to next week's list. We typically close the list about 4 or 5 o'clock on Monday, so we have time to prepare on Tuesday to have all the answers ready to go. So next week, starting on April 9th, is the CAI WSCAI annual conference. There will be a trade show with booths. We will have a booth there. There are educational presentations for associations. It will be a great time, so please feel free to attend. If you don't know how or haven't signed up to attend, please go to wscai.org and there should be some tickets still available, I believe. I will be giving a couple presentations, so I will be there on the 9th. We will have a booth with some of our attorneys present on the 9th and 10th, so we will be there. Feel free to come up, introduce yourselves, and we'll be happy to see you. And because of the CAI conference, we will not be having a Q&A next week. So with no further ado, let's get started. So the first question is, a board wants to make a resolution to have emergency approval on specific items. How high can the approval amount be before getting into trouble? 2,000, 5,000, 10,000. So there's no one answer for everyone. So 6490-502 grants boards the authority in emergencies, but emergency is defined by statute now. So how statute defines emergency is an event or condition or state of emergency declared by a government for an area that includes the common interest community that it has to constitute a threat to the health or safety to the public or residents of the community, threat to the I always have problems with this word, I'm sorry. Threat to the habitability of units or risk to substantial economic loss to the association. So a water leak may constitute an emergency, but having to sign a contract before the contractor says the price will go up, that's not an emergency. There's a risk to the association and to the individual board member if the authority to act outside of meetings is delegated to one person. Typically, what an association may consider to be an emergency may not be. It may be possible to adopt policies for specific kinds of actions or expenditures to allow them to qualify as ministerial, but the legal standard will be if the amount is reasonable, which is not well defined and is always evaluated after the fact. So we suspect that a few associations are trying to use the ministerial or delegating authority to an individual board member or a couple board members to avoid having to have do everything in an open meeting. And the legislature has been very clear that that idea is not allowed. So please be very cautious when doing this. Run anything by your association attorney because we don't want our clients or a potential new client to come in saying, we've had a challenge. Our insurance is not defending us because they say we violated our duty of care and running afoul of statute. There's a lot of pitfalls here. So please contact your association attorney for advice before you start delegating authority like this. Ken, did you have anything to add to that?
Yeah, just I agree that the emergency can't be defined by the dollar value. Um, the statute does have specific conditions. I will note that it's a badly worded sentence because you could read it to say that the event or condition which is threatening the habitability of units must be declared by a government. And I don't think that's the correct reading. It's either one, an event, or two, a condition, or three, a state of emergency declared by a government. Those are the three conditions which could trigger the emergency provision in the statute. And then also I'll note that the emergency provision in the statute, which is RCW 6490-502, still says you're supposed to call a board meeting giving notice to the unit owners in some reasonable manner. It actually says that it is practicable and appropriate under the circumstances. So theoretically, even if you had a fire and had to do something to board up the building or something, the statute is anticipating that you'll still, tell your owners you're having a meeting of the board to discuss how to fix it, even though this says that you don't have to have a quorum of the board to respond and take appropriate actions. So there's definitely a big conflict right now between how the legislature imagines that boards are taking action on behalf of their communities and how the real world functions. And I don't know how long it's going to take before we get either court rulings to clarify that or the legislature revises some of this to make it more practical for managing communities. Next question. Can we collect signatures for amendments by Docusign? Short answer is yes, as long as the association has the ability to verify that the owner who's signing has the authority to do so. Okay. For all of the statutes, the electronic voting is specifically discussed, and Docusign is certainly a way to vote. You can actually use different forms of electronic communication. I know there are a number of electronic voting platforms now, and you can accept an email because an email is also something you can verify. And if you can take reasonable measures to verify, that's the term in the statute, that a ballot has been cast by the unit owner, then you can count it. And I think DocuSign would qualify as a reasonable means of ensuring that the document was signed by the correct person. Anything you want to add, Jennifer?
Just a quick reminder for everyone that's not a Ukiah community now, starting January 1st of 2028, Voting for amendments and elections must be conducted by secret ballot. So if you have a specific form or specific method that you're using for voting now, you need to take a look at that before January 1st of 28 to make sure it complies with the statute. So our next question, if a unit changes ownership during the course of an election, can we still count the prior owner's votes if they were the owner when they voted? So the answer to this is no. If a unit or lot sells during a vote, the new owner's vote counts. The statutory reference is 6490 445, excuse me, 455 sub 4. Unless the declaration or organizational documents otherwise provide, an association may conduct a vote without a meeting. The following requirements apply. And then it goes on to state how those requirements apply. But if the association knows that the unit has sold, we would treat that as a revocation, even though the statute only mentions death or disability of the owner. The reasoning behind this is that the owner who has sold during the election has chosen to leave the community, and the new owner needs to have a voice in that vote because they are the owner as of when the vote ends. Ken, did you have anything to add to that?
No, I agree with that. Next question is, since under Ukiah, boards cannot vote in executive session and confidential information from legal counsel, lawsuits, owner fines, etc., have to be addressed in executive session, and then decisions from the executive session have to be made or confirmed in the general meeting. Does this mean that you have to start the meeting, have the owner comments, then separately, securely have an executive session to address and then resume the open meeting? I think the answer is yes. You are supposed to have your open meeting, have a comment period, and then at any point after that during the meeting, the board can have a motion to adjourn to executive session, at which point you would discuss those items that you have agreed to discuss in executive session. And then you would come back to the open meeting. So if you were adjourning to executive session to discuss whether or not to pursue a foreclosure, because that is something that has to be decided by the board now, you would adjourn to executive session, discuss the foreclosure issue, then go back into the open meeting, and someone would make a motion either to actually send the unit to foreclosure or not send it to foreclosure, and you would vote on that motion. So there, again, a lot of, I think, conspiracy theorists have gotten the ear of our legislature and have convinced the legislature that boards are doing all kinds of nefarious things in secret behind closed doors. So the legislature is forcing all of the activities to be done in meetings where owners can observe, even though most of the owners don't observe or care. And I will say that there are certainly going to be some things where I think trying to comply with the letter of the law starts to become silly. So, for example, if you are scheduling a meeting with an attorney to discuss litigation, I don't know that it would require a open board meeting first and then adjourn to a meeting with your attorney. I also think that if you're in actual litigation and you're needing to make decisions, that some of those will have to be done privately by the board. So, for example, if you are in mediation, you're not going to go into an open meeting to discuss what your settlement position might be before you start your negotiations. On the other hand, I would say that you couldn't actually settle without having a condition in your settlement agreement that the settlement is going to be approved in an open meeting. So there are a lot of I would say, technical issues or very specific circumstances which are going to influence whether or not the compliance you have for holding meetings is meeting the intent of the statute, because it's more important to understand the intent of the legislature than a strict compliance with the exact wording of the statute. But I will offer many courts look at the wording to decide what the intent of the legislature is. I don't know what you want to add to that, Jennifer.
No, I think you've covered it. The next question is, if an association has a late date of the 30th of each month, do they really have to send this as their first delinquency notice? And then this is the person asking the question put into the question the language from RCW 6438-100. This is a notice of delinquency for past due assessments from the homeowners association to which your home belongs. And then everyone knows that particular language because it's in all of the statutes. So,
And in the later portion of the statute, it's called the pre-foreclosure notice.
and we've covered this in prior Zoom meetings pretty heavily toward the end of last year, but the answer is yes. If you want to collect more than one late fee of no more than $50, and interest on the past due amount, you must send the pre-foreclosure notice of delinquency. The statute prohibits from any association from assessing any more late fees or administrative fees for 15 days after that notice is sent. So the particular language that now applies to everyone is in 6490-485 sub 21 sub A. No later than 30 days after an assessment becomes past due, an association must provide the notice of delinquency to the unit owner by first-class mail that meets the following criteria. The notice must be mailed to the unit address and to any other address that the unit owner has provided to the association for transmission of notice, and by email if the email address is known to the association. So you are required to send pre-foreclosure notices of delinquency. How that timing works is no later than 30 days after the first missed payment. So if you have a grace period of 10 to 15 days, you don't count the grace period. It's 30 days from when the payment was missed. And then you are limited, if you have not sent the pre-foreclosure notice of delinquency, to a single late fee of no more than $50 or 5% of the unpaid assessment amount, whichever is less, and an administrative fee of no more than $10 related to providing the notice of delinquency. So the statute is extremely clear that you must use this language. You can do a cover sheet or a cover letter explaining that this language is required by statute, but you are required to send it. Please contact the association to work out a payment plan, but you are required to send this language to each owner when they miss a payment. Ken, did you have anything to add to that?
Yeah, I think really what's going to happen for some clients is they're going to choose to balance the cost or inconvenience of mailing this notice with the lost revenue from the penalties. So if if you have relatively modest fees and you don't care about the late fees and interest, and you don't have administrative fees, then maybe you don't care about going to the effort of sending out this notice. It's just, if you don't send the notice, you are prohibited from assessing other expenses. And so if you have a monthly late fee of $50 a month, that is not going to be something you can assess. This also starts to make it really difficult for anyone who is trying to calculate what an owner owes to the association because it means that the first month's late fee is often different than your published late fee. It means that you may not be able to assess the second or third month worth of late fees because of the timing of this notice. And it certainly made it more difficult for our collection staff to properly calculate what the amount owing from a delinquent owner is because of the way this new statute is applying. And it didn't really start for until the beginning of this year. So we weren't worried about these calculations for the delinquencies in 2024. But now, as we have people starting to send us collections where the first delinquency is occurring in 2026, we are having to go through and make sure that all of the calculations are correct because we have to comply with the Fair Debt Collection Practice Act at the federal level, and we can't put an extra assessment on unless we know it complies with this statute. Got anything else, Jennifer?
No, I think we've covered it.
Well, next question is regarding association records. To be removed from a directory that another homeowner can request and receive, must owners opt out in order to avoid their phone number and email address being given to other owners when asked. So I'm assuming when you say a directory that this would be a book or a list of the owners in the community and their phone numbers and emails. And I know we have some clients that have regularly published and distributed to all their owners the names, addresses, phone numbers, and emails of all the other people who live in their community because they're a community and they want to be able to talk with one another. Under the new statutes, I would say that yes, this practice becomes difficult, and in fact, you should not give these things out unless the owner has agreed to have their phone numbers and emails distributed. The email address became much more confusing in the last year because the statutes require that if an owner asks for a list of owners and their addresses that the association uses to communicate with them, and an owner is using email to receive notice from the association, then the email address is the address that the association is using to communicate with them and would need to be provided to a requesting owner. But then the statute was revised again to say that an owner can ask that their email be kept confidential. So if you have asked owners to accept notice electronically and they gave you an email address, but they did not request that it be kept confidential, then when an owner asks for the addresses of the owners, you would be required to provide that email to the requesting owner. You would not provide the email for an owner who is still receiving mail because the method by which you're communicating with that owner is mail. And so this makes it a confusing issue. It becomes contentious because a lot of associations don't want to have the complete email distribution list that they may use for communicating distributed to every owner in order to avoid either commercial use or what the boards consider spam. So it is something though that we've had come up for a couple of clients now. So our recommendations are that if you are asking owners to consent to electronic notice, you also ask them if they want to have their email address kept confidential. If they don't say yes to the confidential question, then it gets distributed when another owner asks. If they say yes to keep it confidential, then you would still give the mailing address for that owner instead of their email. And before we would distribute phone numbers under any circumstances and emails other than to those people who have requested or are accepting notice electronically, we would ask the owners if and the residents if they're okay with their information being included in a directory. So it's really changed the nature of some communities. We have a golf course community which, routinely published a directory, and they're having to change their practices. And, it's something to sort of see how it evolves. This is again something which may get modified by the legislature on a regular basis. Anything you want to add, Jennifer?
No, I think we've covered it. The next question is, we are in the process of restating our governing documents. There are a few items that are optional and we would like to keep separate for owners to choose, so a single item doesn't stop the process. Examples are capital contributions when purchasing, rental caps, no smoking on decks, etc. Is the vote to approve an all or nothing, or could we have separate out specific items so owners could vote separately on those items? So this is getting a little too specific. You need to ask your association attorney who drafted these documents to get their opinion. And honestly, the brass tacks, it really depends on how many issues you want to pull out. You can have separate votes on certain items, but you run into the problem that the vote may get too confusing for owners to really understand. You can also survey the owners to gauge support on a particular topic. So, one overall thing here is that statute has changed, and capital contributions after the initial purchase of a unit may not be allowed under Ukiah. So if you have that in your governing documents, please contact your association attorney for advice on that. But honestly, if you have a question about a document or how something works, contact your association attorney. They can give you the advice that you need. Ken, do you have anything to add to that?
No, just how you get it approved is really it. It's up to the board, and you can have as many votes as you want. Um, it just may be difficult to calculate when you've gotten enough votes to approve if you're getting, if you're waiting for different approvals on different sections. Next question. And I'll just start with this having an incorrect statement at the beginning of the question. RCW 649525, which is the budget section of Ukiah, goes into effect January 1, 2028. Does an association have to adopt this statute before January 2028 to make it applicable? Okay. And so the correct answer is that 649525, which is the budget section of Ukiah, has applied to every community in Washington State since 2018. It was one of the only sections that applied to every community when Ukiah was adopted. If you look at section 6490-365, there's a list of those sections of Ukiah that apply to older communities today. And that list includes the budget section. It includes reserve study requirements. It includes how the meetings are conducted. That's section 445. It includes the emergency powers of the association section, and a few others, I think EV chargers and heat pumps. So the short answer is that you don't have to do anything to make that section apply to your community. It applies today. You want to add anything, Jennifer?
No, I think you've covered it. So the next question is, can the notice of an ACC meeting schedule be included in a newsletter? And the short answer is yes, if the newsletter is sent as required for notice under the statute. So if an ACC or any other committee exercises board authority all meetings must have notice the same as a board meeting, and this is found, requirements for notice are found under 6432 270, 6434 396, 6438 110, 6490 515. So if the ACC decides approval or denial of applications, they are exercising board authority and would fall under the same notice and meeting provisions as required for the board. If they ensure that the application is complete and give recommendations to the board, but don't actually approve or disapprove, then they are advisory and don't necessarily have to follow those particular statutory provisions. The As we've said before, the legislature has been on a very heavy transparency kick for the past, I want to say, 5 years or so. So if you have a committee, the more exercising board authority, you are required to follow the same procedures as a board meeting regarding notice and conducting the meeting. But if you are an advisory committee, you don't necessarily have to do that, but it's recommended just so that owners are kept aware, and if they want to observe, they can. Ken, did you have anything to add to that?
I'll just add that the reason that the committee has to have open meetings is contained in 6490 445, which is the meetings statute, which applies to everyone effective this year. Next question is a board required to send communications and documents to a bilingual unit owner in that owner's native language? And I'll offer the only statutory requirement to translate any document for the benefit of an owner is the pre-foreclosure notice that we've talked about already. And that's because the statute, which is it's in 6490 485 section A, it states that the pre-foreclosure notice must be provided in English and any other language indicated as a preference by the unit owner. So that's a challenge because we don't know what languages they may ask, and the statute as it's written would require you to produce the notice in any language they asked for. But there's no requirement to produce communications in any alternative language to English for any other owner. On the other hand, you may want to provide something in the owner's preferred language if that will help you communicate and help you resolve some kinds of problems. You might be able to use something like Google Translate, but you would not want to represent that the translation you're providing is the legal document or legal communication, because what you want is for the CC&Rs or your declaration as written to be the controlling document, and any letter that you communicate or board meetings that you have, you want them to follow the understanding that you have in English rather than translate into some foreign language and then they translate it differently back into English. So the other thing I will comment on is we have seen an owner demand a translation as an accommodation of her disability. And if you get a request like that, I would suggest you talk with an attorney about it. Anything you want to add, Jennifer?
No, I think you've covered it. The next question is 6490 445 sub 2 sub J states, after the transition meeting, the board may act by unanimous consent only to undertake ministerial actions subject to ratification by the unit owners, or to implement actions previously taken at a meeting of the board. In the absence of legislative definition of ministerial actions, can the board set criteria for designating certain decisions as ministerial? If so, what are some possible plausible guidelines? A spending limit, a
You
particular
went silent.
I'm sorry?
You went silent for half that sentence.
Oh, sorry. So in the absence of legislative definition of ministerial actions, can the board set criteria for designating certain decisions as ministerial? If so, what are some plausible guidelines? A spending limit, a particular type of decision? As a follow-up, the context here seems to imply that unanimous consent can be obtained through an email vote by the board. Is that an accurate or reasonable assumption? And then finally, can the board delegate decision-making authority for ministerial actions to an individual board member or committee member as part of its policy? So we've covered this a little bit earlier and then also in prior Q&As. So you can look back and on our YouTube channel and find that information. There's no statutory definition or court guidance on what ministerial means, but it's generally understood to be things like signing contracts that are already approved by the board. We do think that boards can define what ministerial means, but that definition must be reasonable. It can be decisions for a particular type or dollar amount, such as approving a carpet cleaning for X amount, tree trimming for X amount, etc. If the board has a motion to approve something but does not have all of the details, then approving details may be ministerial. Policies that might allow for expenditures that are included within the ratified budget might qualify, and you see that a lot in management contracts. Policies that allow for investment of reserves may qualify. Policies for collections and enforcement may qualify. But we recommend if you're doing this, you drop the policy or have your association attorney drop the policy and have it reviewed. The problem here, and this was covered earlier, is that we see boards trying to make things ministerial that may not be. And then you're inviting a challenge by an owner and with possible liability to the association and the individual making those decisions. So the legislature has been explicitly clear that email or any approval outside of meetings is not allowed. They added this one exception for ministerial, but didn't define it. So it needs to be minor and inconsequential or fairly routine things. The board can delegate some decision making, but that delegation must be reasonable and not intended to get around meeting requirements. So you can delegate to committees that have at least two board members to exercise authority of the board. But it would be risky, extremely risky, both to the individual involved and to the association to delegate sole decision-making authority to a single person. So again, as we said before, this is a new statute. There is no case law. We don't want any of you to be a test case. Treat this very, very carefully, and please run any policies or any procedures that you're looking at by your association attorney to make sure it's not violating statute. Ken, did you have anything to add to that?
Well, I'll also, I guess, mention what I call the savings clause in the statute. So under section 2, I think it's J, maybe it's L, at the very end of that statute, which tells you can't do anything without these very strict procedures, there is a section that says that even if you don't follow all the procedures in the statute, the board decisions are still valid if they're not challenged in court within 90 days after they have been essentially published to all the owners. So if you're making decisions in violation of the statute and you're telling the owners about those decisions and giving them an opportunity to come back and correct your procedures, then there's a time limit, essentially a very short statute of limitations. But I don't want to see people acting in bad faith and avoiding the procedures intentionally in order to rely on that savings clause. I think that'll get you in trouble. Question 12. We have 80 members in our community. The last time we tried to amend the bylaws, we only got 30 votes. And even though 27 were in favor, That was not enough to meet the requirements. At a minimum, we'd like to add an amendment that states that we will follow Ukiah, in particular pertaining to the annual budgets and assessments. Is there a way to do this without a majority of members voting yes? So first, as we already discussed, the budget provisions in Ukiah already apply to you. And I'll also offer that if you are a plat community under the Homeowner Association Act currently, any cap in your assessments or raising assessments was wiped out by Ukiah also, because it states that to protect the public interest, only the budget procedures of Ukiah apply to those communities. In terms of adopting Ukiah, there is also a specific section in Ukiah that allows you as a community to adopt Ukiah with a lower threshold of participation. It allows you to adopt Ukiah with a 30% participation rate, which in this example you would have achieved, as long as 67% of the votes cast are in favor of adopting Ukiah. So RCW 6490-370 has a specific process for you to follow. You have to send out the proposal to adopt Ukiah, wait 30 days, hold a meeting to allow owners to discuss it, then mail it out again with ballots. I think you're required to wait at least 14 days to collect the ballots. And then on the day that the ballots are due, you count them. If you have 30% of the members voting and 67% of them are in favor, then you can record an amendment to clarify that you are bound by Ukiah going forward. And I think that answers the question. Did you have anything you want to add, Jennifer?
Uh, just a couple quick things. If you're not able to adopt Ukiah early, there are statutes that still apply, and those are found under 6490-365. Also, the legislature decided that they didn't want to bother with changing all three, besides Ukiah, of the prior association statutes. So 6490 will be the only statute that everyone falls under starting January 1st of 2028. Ken, did you want to add anything to that?
No, I'm good.
Okay. So our last question, and if you that we've prepared ahead of time, and if you have questions or want clarification, please put them into the chat. We will be able to get to probably a few of them before time is up. So our last question is, we're working to keep our members who lack or don't want to use email accounts well informed and properly notified of board and member meetings. It isn't troublesome to post our agendas via US mail, but the board information packets are large enough to be a big task and expense for surface mail. We already publish the informational materials for all open meetings on our website. Are the Ukiah requirements for notice satisfied by sending out the agendas by surface mail with a note directing members to the supporting material on the website? Does this approach also require written consent as is necessary for email communications? So how you're doing it should work. The statutes that in question is 6490-455 sub 2 sub G, 445 sub 2 sub G. If any materials are distributed to the board before the meeting, the board must make copies of those materials reasonably available to unit owners, except that the board need not make available copies of unapproved minutes or materials that are to be considered in executive session. So the statute just says that board materials must be reasonably available to owners. That might mean providing a paper copy to an owner who requests it, but informing them that this is an association record, and under the record statutes, they can be held responsible for a reasonable cost for copying. So the board meeting packet does not have to be included in the meeting notice, and it can be made available on request or posted on the association website, however you want to do that. Ken, did you have anything to add?
No, I think you covered it.
So, Diana, are there any questions in the chat?
There is just one, and it's not really clear if this is a question. I'll read it out loud, but it says, as volunteer board works per duties, etc., requesting bids, quotes for work on the property. As a board, we get bids, board chooses vendor, then schedules the work, and then action item goes into meeting minutes. I think this is asking, could you provide some clarity on this topic? Oh, and Sharon said I could add more details if needed.
Just unmute yourself.
So, oh, Ken, you're muted. There
Yeah,
we
why
go.
don't you just unmute Sharon and tell us your question?
Thank you. So we're a volunteer board, 34 owners. The board has always done the work of getting bids and planning work because the board is voted on to be responsible for the budget and the property. So when owners, we just came up last night, some owners are demanding to see every bid we get to look at everything before we do it. And normally it's done and it's in the, if it's in the action, it'll now be in the action items and it's in our financial report. So for me, learning all this is like going to law school. So I get some basics and then I get lost in some other explanations. But I'm just curious if there's a RCW or a new rule on um, the board not functioning as the board, getting the bids, making the choice of which vendor to go with, planning the work, and then putting it in the documents, the action items, and in the financial report.
So I think that there's really not any change in how the procedures would be followed by the board, and the volunteers would still get bids. The only difference I might see is that the bids would be something that the board would consider in a board meeting.
Yes.
So they would be in the board packet, which if the owner requested, would need to be made reasonably available to them before the board has made a decision about who to hire. So presumably you would collect the bids the same as you always have, and they would be gathered together and reviewed by the board. And so the bids would be something that the owners would have available to them if they requested in advance of the meeting. The owners would be able to attend the meeting and listen to the board when they make the decision about which vendor to hire. The owners don't get to participate in the discussion about which board to hire, but they get to be at the meeting and listen to the board while the board is making that choice. And then after the board has hired a contractor, the contract would be a record of the association, which the owners could request at any future date. So the idea behind the legislature, at least we think, is that the board can't just get bids and hire someone and then at a meeting announce who they've hired. They have to make the decision in an open meeting.
Okay. Thank you. When you say our board, we have 4 people that consistently come to the meetings and they're like a mob. They won't be quiet. They challenge everything. They ask questions. It's been kind of stressful and challenging because they are arguing and sabotaging and just causing more troubles than just listening. So, and I remember last month it was just don't buy into it, or I'm trying not to babble about some of this upsetting stuff.
Yeah, so
So,
how to deal with unruly attendees at a meeting is, going to be a little bit different for every meeting. If you're doing Zoom meetings, it is okay after you have given one warning to an owner that they need to stop disrupting or stop interrupting or however you want to phrase it. It's okay to mute them, and if they keep unmuting themselves, it's okay to actually remove them from the meeting. The
Okay, thank you.
statute actually says that you can remove a person who's disrupting the meeting from the meeting.
Thank you.
If you are doing it in person and they refuse to leave and refuse to behave themselves, then you can just end the meeting and reconvene at another time.
Thank
Uh,
you. My next question, because I thought about that last night. It was our 15 minutes, they took an hour arguing about everything. And I reminded them and stayed calm and all that stuff. But I just needed this clarity.
So the
Um,
statutory guidance for this is in 6490-445. It's applicable to everyone now. I believe subsection 2A, the beginning of the statute talking about board meetings has the language regarding ejecting people who continue to disrupt after being warned.
okay.
We have had associations have a excuse me, off-duty police officer come as a calming presence for an in-person meeting when they know that there was going to be a disruptive owner. We've had other associations have one of our attorneys present to run the meeting so that the agenda can be followed and people are more likely to be mindful of the propriety and courtesy.
Okay.
Um, it really depends on your association and how you hold meetings. But
yeah,
in,
I
oh,
would
go
offer
ahead,
that
sorry.
one of the ways to keep it from turning from a 15-minute comment period to an hour is don't argue and don't respond and don't make accusations. So even if someone says something that you believe is an outright lie, if you don't engage with them, it will not extend the conversation. And so the statute's pretty clear that you only have to give 15 minutes and 90 seconds per person. So if you've got 4 people show up and they want to take an hour to talk, you just can stop them at 15 minutes. And you can say, we have an agenda we have to get to. So the owner comment period is ended. And again, if they really are making it difficult, just adjourn the meeting and schedule another one.
Okay, that would be the next step. I'm pretty good at not reacting. And then this, when I stated the new rules that we're in transition, we're learning all these new rules, we're moving forward, all that prep stuff, and then did that 90 seconds per, they just don't accept it. So I now will do what you're suggesting, just stop at the 15 minutes, and then if it keeps on, just end the meeting. Thank you for that. I needed permission, I guess. Thank you.
So there's a question in the chat. Disruptive concept. If a director is logged off a video meeting and there is no longer quorum, do votes count?
So that one is an easy one to answer. Any decision of the board can only be effective if there's a quorum at the time the decision is made. Okay. So if you had a board of 5 and only 3 show up, you have a quorum. But if one of them drops out, there can be no other decisions made because you no longer have a quorum of the board.
And I believe we have time for one more question. If anyone has a question at the top of their head, please put it into the chat. If not, we may be done a little bit early.
Well, I've got plenty of things to do, so I think we just call it. And there is no meeting or no Q&A next week because the CAI conference is occurring. So we will have another one of these in 2 weeks.
Have a good
Alrighty.
week, everyone.
Thank you, everyone. Thanks for joining.
Thank you, you guys. Appreciate it.
Oops.